Okay, welcome everybody to our Sharpen the Saw series. We're going to become better professionals and we're going to look at the REPC in a whole new light. Were you aware that there's zombies in the REPC? It's crazy. There's things that live on forever. Well, maybe not forever, but they live on. Right, Mark? I mean, we're talking, they live on.
They do.
I'm joined today by our in-house counsel, Mark O'Brien. Thank you, Mark, for all the work I'm putting, all this together too. I appreciate. Hey, Amy also did all the graphic work, so we're looking good. I hope you have your printout ready to go, and we're going to take some notes on this. First of all, let's get the class heading down so you go in your realms, you can find it. Everyone write this down. The class ID number is RC, and Joe, you could put this in the chat here, RC 200 541. Okay, that's the class number. That didn't get printed on the handout. Sorry about that. But you'll find that on Realms here in about 3-4 days from now. Thank you, Joe. Look in the chat. There it is. And you'll find your 1 hour of core CE. So today we talk about something that's a different way to look at the REPC. As I said in the email, that you're never going to look at the REPC the same. And as Mark and I were kind of going back from maybe a traditional thinking, a way of thinking about how real estate transactions work, if we went back 20 years or 50 years, there's this idea that a buyer or seller sells the property, and when the transaction's done, it's over. It's like that's a conclusion, and there's really nothing more to say about it. And the idea of caveat emptor, buyer beware, was really emphasized in those days. So, hey, buyer, you got what you got. And it's kind of like cutting the cake with our kids, the birthday cake. You say, look, you get what you get and you don't throw a fit. Anyone else say that as a parent? Am I the only one? It seems like every time I cut the cake, right? I want the corner. Oh no, I want the one with the apple. So I go, hey, you get what you get, you don't throw a fit. Well, that caveat emptor, get what you get, was pretty pronounced, in old traditional ways of real estate transactions. The trend is to really get away from that. There's precedences that are set in the courts about how we look at things that live on. And if you really take a look at the REPC, in which we're going to dive right in here, we're going to find things that prove that there's zombies in the REPC. Okay. So, Mark, I'm going to take everyone through our objectives, and then we'll jump into this timeline discussion right away. So sure. Let's go to share screen. Everyone follow along and get ready to take some notes here. So here's our handout. And the objectives today is to understand which provisions live on. Some say very specifically, number 2 here, shall survive closing. You've probably seen that a number of times. We've identified all the paragraphs that literally say that. We're going to understand what that means, what the implication of surviving closing means. We're going to understand the things that do expire after closing. And how does this relate to agency duties? Mark, you and I were talking about how that might be a sense of confusion.
Right.
Yeah. So agency, we'll contrast that against how we look at agency. And then, of course, as always, why is this important to buyers and sellers? So, Mark, I tell you what, why don't you kind of describe timeline here and this concept of settlement and closing so that we have a jumping off point?
Sure. And, the reason I put this in here is because a lot of buyers and sellers, as Will alluded to, probably think that, once the house is sold, the seller receives their money, there's finality. And I wanted to initially focus on the two concepts we're well aware of, settlement and closing. Two different things, but closely related, which leads to that perception, perhaps, in sellers and buyers. So let's walk through settlement real quick. As you know, settlement occurs when buyer and seller have signed and delivered all documents required by the REPC by the lender, by escrow provider, and monies other than loan proceeds payable by either party have been delivered to escrow for ultimate distribution. The closing occurs thereafter. Closing occurs once settlement has been completed, and any loan proceeds that are coming from a lender are delivered to escrow, and the actual recording of documents with the county has occurred. So I put that in there again because it sounds pretty final. It sounds like the resolution of the transaction. Everybody walks away, the monies are exchanged, the property is exchanged, possession often is exchanged at closing. And so our common understanding is that closing and settlement is the end of the transaction. And that's probably what a lot of our buyers and sellers think. And that's kind of the whole purpose for this class, is to discover what provisions survive after closing. And we call them zombies, which may or may not have a negative connotation, but we'll get into it in a minute, but they're not necessarily negative. The idea behind them is that the buyer and seller receive the benefit of the bargain that they understood at closing. So these zombies survive closing to make sure that the parties got the benefit of the bargain. So we can get into those here specifically.
Yeah, so this is the list, guys. So let's go to page 2. And here you'll see all the sections of the REPC that literally say survive closing. So we're going to take one of these at a time. I think, Mark, I'll use this. Yeah, I'll just follow along on the REPC here on the screen. We've highlighted these. So let's tackle, look, we got a lot that's right here, 3.3, 41, 42, 43. There's a lot of surviving here that goes on. So let's just tackle one at a time. Let's start off with 3.3 and possession. Mark, you want to take everybody through that? Here's that survive closing right at the end. If you've got a REPC handy, take a look at that. Matter of fact, that'd be a really good idea. Grab your forms book. You A students, grab your forms book, look at the REPC and notice survive closing in 3.3. In the handout, we've put seller, buyer, and who benefits, because clearly, there can be an emphasis on one side or the other. Mark, you want to take everybody through?
Yeah,
it survives.
And Will just pointed it out, but keep that in mind as we go through these, who benefits. And that was sort of an education for me as I went through it. In thinking about these as zombies, let's not think about them as zombies, because oftentimes they benefit both parties. And in 4 cases, they benefit predominantly seller, and 3 cases they benefit predominantly buyer. So it's really kind of balanced. So let's keep that in mind as we go through. 3.3 is the first provision that expressly says this provision shall survive closing. And it deals with possession, as you can see. And except as provided in 6.1a and b, seller shall deliver physical possession of the property to buyer as follows. Well, if for example, if we check blank calendar days after recording, remember recording occurs as part of closing. So that provision will need to survive closing such that the buyer can enforce his or her right to possession of the property. So it makes sense that that provision survives.
Yeah, hey, Mark, and I think there's a reoccurring pattern here. Okay, mm-hmm. That closing, although closing sounds like we've shut the door, all of these are going to repetitively say the door's still open. You may own the property, monies may transfer, but there's still promises like possession that occur post recording. Right.
Right.
So,
and again, those promises and the reason they survive is to make sure the parties get the benefit of what they bargained for in the REPC.
Right. Okay. Do 4.1.
Sure. 4.1, prorations. All prorations, for example, HOA dues, property taxes, rents, shall be made as of the settlement deadline, and unless otherwise agreed to by the parties. The writing can include the settlement statement. So this survives closing kind of for obvious reasons. What if there's an error on the settlement statement? What if something wasn't properly allocated or prorated between the parties? it makes sense. And that theme is constant throughout all of Section 4, which is prorations, assessments, and other payment obligations. These provisions generally survive closing for the purpose of going back and fixing or correcting what should have been done on the settlement statement more often than not.
Perfect. Okay. And Mark, I'm going to remind us both that we're going to do a little interactive quiz question here in about 5 minutes. So
Sure.
I've got a question ready. So let's go on to the next section. Let's see. We did prorations. Now we're at 4.2, special assessments.
Sure. Special assessments, a lot of them will appear in HOA documents, or they could be any other governing authority that has the ability to assess a property. This says how they are to be allocated, either by seller, buyer, or split equally. And in order to make sure that that happens properly, and the agreement of the parties as reflected in the REPC is carried through after closing, this provision survives as well.
So it could be assessed prior. There's a very key word here, prior to settlement. See, it's assessed prior, but it may be paid for after.
Right.
So again, a very important way to look at the REPC, that something's happening post-recording, post-closing.
Mm-hmm.
Really good, different way to look at it, isn't it?
Yes.
Okay. All right. 4.3. Let's do this one. We'll get through this section and then I'll do the quiz question.
Sure. And the theme is constant here. This is really allocation of expenses on predominantly the settlement statement. 4.3A is the sharing of escrow fees. And to the extent that wasn't done properly on the settlement statement, we can go back and fix it. 4.3B, rental deposits and prepaid rents. Those are to be, you see at the end, credited or paid by seller to buyer at settlement. To the extent they miss one or two, those can be cleaned up post-closing by virtue of this provision surviving. 4.3C is transfer fees. You see that they take on a lot of different names depending on your neighborhood or development. They're paid based on a transfer of ownership in the property. And those can either be allocated to seller, buyer, or shared equally. Again, this would be a cleanup after closing to the extent those transfer fees were not properly allocated or paid. Utility services, again, buyer's responsible after the settlement deadline. To the extent that doesn't happen, to the extent the transfer isn't done properly with who is it, Rocky Mountain Power or Questar. I guess that's Dominion now, but to the extent that isn't done, we can go back after closing and clean those up. And finally, 4.3E, if you look over who benefits from that, I have that one as buyer benefiting because it allows the escrow company to withhold from seller's proceeds enough funds to pay off any mortgages on the property, for example. And that survives closing as well, so that the buyer can receive the benefit of its bargain again and make sure that they're receiving the property free and clear.
Yeah, so all of these have to do with, there may be, well, they're not maybe, it's very common when in a real estate transaction to have a lot of this taking place after the deed is recorded.
Right.
So I think it's very common. And so I think it's important to remind our buyers and sellers that these obligations extend, past closing.
You might get the question, what if my settlement statement's wrong? You might get that question. And you might point to this section 4 and say, well, we have an opportunity to fix many of these items, and you can walk your buyer or seller through that process.
Right. Right. Okay. Time for a little interactive quiz question, guys. Please grab your chat. Here's the question. How many sections of the REPC literally say shall survive closing? How many shall survive closing? Literally say that right here. You can see we've already counted out a few. We've got 3.3, and so here's 1, 2, 3, 4 sections, and we'll count these subsections also. So yeah, go ahead and interact, please. Appreciate everyone multitasking minimally. So, it's hard on Zoom, isn't it? Because we've gotten so used to doing multiple things. So appreciate your attention. This is good stuff, to understand that how we look at our duties and our value proposition. Here, I'm going to stop sharing for a second because I'll come back to this probably at the end. But so much of what we're doing is trying to show our buyers and sellers the value that we have. We're our own worst enemy. We oversimplify. We say things like, well, you know what? We can get this done. And we don't really show the complexities. And our job is not just completed upon closing. There's still things that need to happen after. And sometimes people say, well, you got paid. Boy, that was a quick, 30 grand, 20 grand, 50 grand. Well, there are things that happen post-closing. We need to start reminding people about the scope of what we do and how that relates to their promises and what the liabilities are. So, all right, we ready for the answer here? Now I've counted, I think, the dominant number here, Mark, but I'm seeing a few different answers. I see 13s.
I saw some 13s, yeah.
Yeah, some 10, 13s, 14s, even 15, 8, 12, 5. Okay. All right, Mark, go ahead and give the answer, because if I'm wrong, I'll just go, well, Mark, what's the answer? No,
it's at the top of page 2 of our handout. 14 zombies, if you will.
Yeah, that's what I've got. I got 14. That's counting the subsection. So congratulations if you counted that right. You can look at page 2 and count those up. And I count 14 there, right? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Yeah, 14 with various benefits to different parties. Okay, let's continue on. We'll go back to share screen, and we'll continue where we left off. We'll keep picking off these zombies. All right, let's go to section 6, and this is title. And notice that we've got another, shall survive closing here at the end. Why is that important? So we'll tackle this one. So this is long-term leases and rental agreements. Well,
yeah, we should say that 6.1A survives. 6.1 itself, that lead in, it's kind of a sloppy numbering of Article 6, but 6.1A is what survives. Long-term lease or rental agreements, and 6.1B, short-term rental agreements. Those are the two that survive. Title to property doesn't necessarily survive.
Right, and here that timeline not expiring prior to closing. So there again, something's crossing over that mark in the timeline. Closing is not finality in many of the REPC terms. So we're addressing literally, hey, this is going on. It's post closing. So what's our agreement?
Right. And I'll point out that, the ones we've been through, 3.3 and section 4, those are, they have the potential to be bigger ticket items, but generally they're settlement statement adjustments. We're starting to get now into some of what I'll call bigger ticket items, the rental agreements and due diligence items, condition of the property, where we could be talking about bigger dollar adjustments for buyer and seller. So 6.1A and B are the rental agreements, both long-term and short-term, that the buyer takes the property subject to the extent they don't expire prior to closing. You'll see in section 7, those are provided as part of the seller disclosures, as you know. So these survive closing because the buyer, the terms of those rental agreements by definition extend beyond closing. They're executed prior to, and they don't expire they're executed prior to closing, and they don't expire prior to closing. So the buyer has to take subject to them. So naturally, that obligation needs to survive closing. Fairly straightforward.
Agreed. Okay, our two favorite sections. Maybe there's a little sarcasm in there because this is where we see a lot of problems coming up in 10.2 and 10.3. So if you've got the REPC, grab that. So this is our, this is our as is condition section in 10.2, and then 10.3 is the requirements really to earn the protection of as is. So it's interesting, Mark, that we've got to put the survive closing on something that's as is. It's almost kind of like, yeah, you're buying what you buy and this is over, but yet we're saying, hey, this survives. Isn't that an interesting kind of like a 180 in its own paragraph, where there isn't finality here to as is? There's going to be things that are going to live on, and how do they affect buyers? Now, I'm assuming it's still true today that the majority of the lawsuits are coming from misrepresentation on the condition of the property. The buyer feels damaged because they inherited something they did not know, and then the lawsuit ensues. Is that still your view of the number one?
That's very much the case. Where I see disputes in the past, where I've seen the disputes arise, it's really mostly a function of what the seller knew about the property. And so we get into seller disclosures. We get into 10.3, which is the requirement for the seller to fill out the SPCD, for example. And the reason 10.2 survives, as Will pointed out, even though it's buyer accepting as is, it's the interplay between 10.2 and 10.3, as Will alluded to. The buyer's accepting the property as is. However, the seller has to fulfill its obligations in 10.3 for that to be true. So the interplay between those two requires both to survive.
Yeah, you guys have heard me talk about this before in a previous CE class. I wish that these were in reverse order. I wish we could say, hey, if you want as is protection, you have to make sure that you're doing everything here. Remember the class we had, should it be disclosed or does it have to be disclosed? We get people saying, does this thing have to be disclosed? It's an interesting way to form the question, because it sounds like, does the law force me to? And we're saying, well, should you? Because anything that you put out there, you're going to earn the right of this as is protection. If you keep it private, if you do not disclose whatever this thing is, as minimal as you've convinced yourself that it is, if you hold on to that and that becomes only known to you, then is later discovered, this as is protection, it's not going to live, it's not going to exist because of this survive closing. It's still there. You still have a duty to disclose this. You didn't disclose it, therefore you're not protected. So I'm always referring to that as the baton, the bad baton you don't want to hold. So give that away. Or, I've heard some people say, like it's the crazy monkey, right? Well, don't hold it. Give it to the buyer. Let them cope with it however they want to cope with it. Then we're owed the protection of as is. So I do wish they were, if I had my way, we'd switch these. But traditionally, I think 10.2 goes back, gosh, decades on
Yes.
the iterations, if I remember.
That's the modern day representation of caveat emptor, is 10.2.
Right.
If we take a step back for a minute and think, as Will alluded to, kind of the value proposition, what does this mean to my buyer and seller? And I focus on 3 because those are, again, the big ticket items. How can we explain this to our seller, for example? How oftentimes sellers think, well, we get to the closing, that's seller's property condition disclosure, can't come back and bite me. We close, the transaction's final. Well, this is how you have to walk your client through, your seller client through the importance of taking time with that seller's property condition disclosure, and not just, as many of you have probably seen, drawing a line from the top of the page to the bottom through all the no boxes. It's kind of a red flag for me, and it should be for you as well as a listing agent. This is how you add value and say, hey, if you don't take time on this disclosure, this is how it can come back and bite you 3 years down the road.
Yeah, we often hear, let's address this one, Mark, the one where they say, well, I haven't lived in the property.
Right.
So this comes up a lot. And I'm going back to the short sell days where there was a lawsuit against Bank of America that paid, a division of Bank of America paid invoices to contractors to do various repairs on properties they had repossessed. But then when they went to disclose to the buyers that were considering purchasing these, they mentioned nothing about the repairs that were made by contractors during the time in which they owned the property. And they said, we do not own the property. Or, I mean, we not only own it, but we've never lived or occupied the property. Okay. So they wanted to hide behind, we've never lived there. You know, we've never occupied. Okay. Well, how do you think that went? So, Mark, can someone hide behind that if they never occupied the property? Can they say, well, since I've never occupied it, I don't owe you any disclosure?
No, they can't. Interestingly, I reviewed a development REPC, not a standard REPC yesterday, and it was for shell construction. And I commented that perhaps you might want to consider a property condition disclosure, which sounds strange. You know, what can I disclose? But it gives you the opportunity as the seller to disclose everything you know so that you can pass that baton over to the buyer.
So a good listing agent is going to make sure that we've really gotten it all out there so that we can earn the protection of as is.
Absolutely.
Yeah. Okay. All right, let's continue on. And let's see, I think we're down to maybe the ones that would obviously need to survive closing because they deal with problems.
15 and 17,
Yeah.
mediation, attorney's fees, those are quite obvious, and they expressly say that they survive closing for obvious reasons. Any dispute arising after closing, looking at section 15, mediation, any dispute relating to the REPC arising prior to or after closing shall or may, a whole different CE. Maybe to mediation. That survives closing, as does, you know, if anybody has to bring a lawsuit to enforce their rights, to attempt to obtain the benefit of the bargain that they understood, well, the prevailing party can get attorney's fees if the judge awards them.
A couple of points on this. First, on the mediation, to summarize this, most of the time, guys, most of the time, we want to see shall here, but it's not literal. You know, you got to analyze each transaction. What I think my instincts tell me that most agents have made up their own personal opinion, and then they are the ones who are choosing these boxes. That's the wrong way to go about it. So I think most of the time there is a better way to go with mediation than have this option. The option, I think everybody likes options, but I get that. But the problem is the other side. You know, you want to commit to each other that there will be a solution here. We did talk about this in great depth in another CE. So you could, I think we called it the Great Debate. It was during the elections, if I remember right. So we were calling it the Great Debate between shall and may. But there's more. If you want to do a deeper dive, grab that other class again. Mark, I learned something. I shared this with you a couple of weeks ago, but I thought this was interesting. I always thought that this kind of concept of a prevailing party was like, well, I won the lawsuit, you know, like I was awarded monies, and therefore I'm entitled, because I was awarded monies, to attorney's fees. But I had an attorney, a judge in a mediation, say to the attorney that was representing the seller, that just because there may be monies awarded in one piece of the argument, that didn't mean they were prevailing. That it was like the case could be divided up against, you know, different points that were being argued.
Sure.
And that if you won one of them out of, say, 6, you know, that didn't make you prevailing. Can you shed some light on how does someone really get awarded attorney's fees when the lawsuit or litigation might be multifaceted? You know, there might be, you know, I want monies for the deck, or I want plumbing, or I want the sewer line. And, you know, you didn't tell me about the assessments, or, you know, there's multiple points in it. How does someone prevail and actually earn attorney's fees? Is that a good question, guys? Would you like to know the answer to that? Yes? Okay, well, thanks, Lisa. Look how excited Lisa is to know this answer. She's so excited.
It's a
Okay.
great question, and it's one you somewhat answered. But for attorney's fees in most states, there has to be either a contractual basis for the judge, for the court, or a mediator to award, or an arbitrator to award attorney's fees, or there has to be a statutory basis. There are statutes which expressly provide that a prevailing party in trying to enforce that statute or their rights under the statute is entitled to attorney's fees. Now, all that being said, whether it's contractual or statutory, the court, I use that term loosely to include judges, mediators, arbitrators, they have quite a bit of leeway, quite a bit of discretion in determining who the prevailing party is and what level of attorney's fees to award. They may look at the 6 different claims. There's claims, there's cross claims, counterclaims. They may look at all of them in their entirety and just do an allocation of attorney's fees across those. Very rarely will you see a case where, well, I won't say very rarely, but there can be cases where one party prevails on all of the issues and the other party is required to pay all the attorney's fees. That happens. A lot of times you also see one party prevail on some of the issues, the other party on other issues, and there'll be an allocation, a fair allocation at the judge's discretion of attorney's fees. So it's not a hard and fast, the winner takes all, that's the important takeaway here.
Yeah, because it kind of feels like the prevailing party, and it does seem like a catch-all, and it's really not.
No, not at all.
Yeah, I'd say, how many? Is that news to anybody? Is that something new you didn't know? Yeah. No, Seton said no. I knew that. I knew that. Okay, well, good. All right. Grab your. It's time for another quiz question. To make sure everyone's still alive. So grab your chat. I've injected this one, Mark. This one, I don't know that we have an exact answer, but I'm going to put it out there. Here's what we're going to do. I'd like you to think of we've got the sections listed there, right, that have this shall survive. Here's all the ones that say shall survive. But think about this. Name one section that lives on because the nature of what it is, but it doesn't say shall survive closing. Name any section. Now there's a few, okay? So let's see if you can name any of them that live on because the nature of what they are, and quit phoning a friend and looking at what Tyler says or Michael says or Peter says. No phoning a friend here. You're like, well, Tyler's a smart guy. I think I'll go with what Tyler says. Need to make sure that you're alive. So please interact so we know that you're paying attention. If it comes down to, I notice we've got 112, we may be one over. Is that right, Joe? Are we one over or no?
We've had multiple other people say that they don't need CE or they could get CE if it's available. So I think we're right in that little sweet spot there.
Okay, perfect. Okay, well, if you need CE, please make sure you're interacting here. So we're going to go into these. What about addenda? We're going to talk about resolution. I did pull up a copy of that, Mark, so we can look at that particular section. Okay. And then what if the REPC is silent regarding survival? I think that's what we're talking about now. And then how does survival affect ability to collect damages? So let's go back to our handout. Here's where we are here. Okay. Well, we're going to save the answer to when we get down to what if the REPC is silent? Why don't we answer the question that I asked you right here? Sound good? Mark, is that good?
Sure.
Okay. All right. Well, let's talk about what about addenda. So we've got, additional addenda to attach the REPC. Do they survive? Is there finality? How do we know if anything in the addenda would live on? So I've got an answer here, Mark, but do you want to take it and then I'll fill in?
Sure. Well, it sort of plays into what if the REPC is silent regarding survival. So I won't steal that thunder from you, but if something in the addenda should survive closing, it should say that it survives closing. What if it's silent? Well, then we get into the question that we'll kind of get into when we answer the third question there. Well, should it survive by its nature? Is it something that requires action after closing that we're not going to know if it was violated or not? So by its nature, should it survive? You can rely on that, but it's better to say in an addenda, if you want it to survive closing, it's better to specifically say, use the language straight from the REPC, the provisions of this section 2 of this addendum survives closing. That's the best practice.
Perfect. Okay, I think what you would write here is if a party agrees to provide, comma, include, comma, or act post-closing, then we would need the language that says survive closing. Now, a note there is this should include help from your broker and Mark, right? So yeah. we shouldn't be writing language in addenda, but that's the high level understanding there, right? So and by its nature, if we're going to provide, include, or act, okay, then we need to address that if it's post-closing, that it survives.
Yeah, the question is, you need to ask yourself, is my buyer or seller going to need to enforce this provision potentially after closing? If the answer is yes, it needs to survive.
Okay, I think that's a good transition to resolution to due diligence. So here's an example of an addendum that addresses something that could happen after closing. Remember the unfinished repairs? Everyone paying attention? Look at the screen here. So they have not been completed. That means we are post-closing, see, after closing. So we've got this concept of surviving, but it doesn't say that anywhere, does it? Anywhere in here say, well, it does here, doesn't it? Right there.
It does in 3.1b.
3.1b, not up here, down here, survive closing. There again, there's that concept. You know, this is the part of real estate transactions that drives us all crazy, because we make a promise up in here. And, you know, we've been through this before. This is the last thing we want to mark, right? We would really rather see this. We'd rather see a reduction. The last thing we want to do is have a seller make repairs on a house they don't care about. But sometimes there's no way around that. Then it gets worse when they don't do it, right? So, you know, we turn a nightmare into a zombie nightmare because this thing goes on and on and on. And these zombies are causing us problems after closing. The quick advice here, I think these are minefields, guys. Both of these have got serious consequences. For unintended purposes, 3.1a, I believe, is a no zone. Don't go there. If you're on 3.1a and you give a buyer the right to cancel the entire transaction based on a few minor repairs the seller agreed to, you're setting yourself up for some serious problems. I think it's better to say we're going to complete this, and then we'll address the things that were remedies after closing. And there again, zombies are living on after closing. Anything you want to add to that, Mark? I think we wanted to emphasize this because this is a common problem, but what am I missing there?
I think in terms of survival, numbers 1, 2, and 3, those are things that happen prior to closing, prior to the settlement deadline. The payment of amounts at settlement, the purchase price reduction, the repairs to be made by seller under 3 are repairs to be done prior to settlement. So there's no reason for any of those to specify that they survive closing. The survival of closing aspect comes in 3.1 if there's an escrow agreement. Clearly that would survive closing to make sure the repairs were completed. 3.1A, there's no need for that to survive closing because it terminates the REPC. 3.1B, that by its terms expressly survives closing so that the buyer can pursue any remedies that they would like. So
Okay, we could do a deeper dive into that, but very well said. Okay. Okay, I guess we're back to our handout on which what if REPC is silent regarding survival, and then what sections live on. Mark, do you have an exact accounting of how many sections by their nature live on?
No, but I could do it fairly quickly.
I don't know if we counted them, but we talked about a couple of obvious ones.
There's at least 8. There's at least 8 that are obvious.
Okay, let's tackle one. Which one would you like to highlight?
Sure, we can start with 1.1.
Yeah. Okay.
You'll notice 1.1 does not say anything about expressly surviving closing, as we've seen in 14 other instances throughout the REPC.
But clearly, and you think about the fact that the possession, you know, look, possession is after recording, but we're going to be owed everything that is in 1.1, but it doesn't say survive closing.
That's right.
But clearly it does.
Clearly it does. 1.2 is another example, carrying over from 1.1.
Right.
I would argue 1.3, 1.4, all of those survive closing as well.
Yeah, 1.4 particularly. Well, I guess to protect the seller, right? The excluded items that also survives closing.
Exactly.
And certainly our water service. You know, if those instruments are not happening until post closing, you're still obligated. So yeah, there's that could certainly be a zombie, Mark. That one, I've heard of some nightmares in the water area
Sure.
of things because they do live on. Do you want to address any others that are, I guess?
Well, I think we can maybe get into 11, which is which harkens back to 1.1 and 1.2. The idea here is that these provisions, by their nature, which is the kind of the argument or the term that you'll hear, by their nature, they have to survive, because if I don't get possession until 10 days after closing, well, what if I walk into the house and the washer and dryer are no longer there, but they were included items? By their nature, that term has to survive so I can get the benefit of my bargain. So it's so obvious that they didn't feel the need, the drafters did not feel the need to say that it survives, but they survive by their nature.
So 14 sections that say it, and at least another 8 that don't say it, other than by the nature of what they are, which 11 is the best example, I think, in the whole REPC. It does wrap up 1.1 and 1.2, and then also 8.1. We skipped over. I think we're kind of, you know, we're eating up our time pretty well. But you remember in anything that is agreed to here in section 8 in our due diligence, that's going to become an obligation that has to be met in section 11, which we have is our items, and that would certainly, because it's post closing, the delivery of that, it could be post closing, then that's going to live on also.
Right.
So go ahead.
No, I was just going to say, it doesn't say in section 11 that the provision survives closing, but it kind of says it in a hybrid. The failure to conduct your walkthrough shall not constitute a waiver of their right to receive, again, the benefit of the bargain, the right to receive those included items, the right to receive the repaired items under 8.1B2. So it doesn't say it survives, but by its nature, it has to. Again,
that's a good way to look. You know, are you seeing the REPC guys in a little different light? You know, it's wow. There's not a lot of finality to closing. You know, although you may own the property, there's not a lot of finality to these contracts. They do live on, and they don't have to actually say it. That's kind of what we have listed out here. This common catch-all for survival is that all provisions of the REPC, which by their nature should survive termination, they shall survive termination, including without limitation, this is to protect everybody. Mark, I think we put a bow on the or the high level thing here. Guys, write this down. This is consumer protection. If we jumped up to, satellite view of why are we seeing reminders that say this survives, this survives, this survives? Because this is consumer protection. It's the I guess it's the medication a little bit for the injuries we could receive by caveat emptor. Yes, buyer, it's on you to make a decision, right? And we're saying that so loudly in section 8 of the REPC, right? We're reminding everybody in section 8 in their due diligence. These are the kinds of things here, 8, and then where you see such as right here. This is that big long list that goes along with buyer's due diligence checklist. Here are all the things that you could consider. And that does kind of put weight on the scale of caveat emptor. But every time we say survive closing, survive closing, survive closing, it's a consumer protection in the contract to make sure that they're getting the bargain in which they negotiated for. So that's a good way, to look at it, I guess, in a different light. We're coming up on the tail end here. Okay, here's another question. Let's do another question. Grab your chat. Let's see how good you guys are at this. I asked Mark yesterday, I said, hey, if everything lives on, and we're talking about a contractual dispute in real estate, what is the statute of limitations in Utah for a contract dispute involving real estate? You guys want to take a guess at that? How many years is the statute of limitations for a dispute regarding a contract with real estate? Go ahead and take a guess. Let's see who gets it. All right, you're filling it up here. Let's see. 5, no idea. 7, 5. Okay, are you guys all just copying Rachel? I know Rachel's smart. I think Jimmy was just nodding his head. Yeah. Someone's going, I know Rachel. I'm going to go with 7. You know what though? Craig Lelis is pretty dang smart. And he put 6 down there. So, what do you think? Jim goes with depends. I think that's also wise. But okay, Mark, do you want to let everybody know what's the statute of limitations?
I would follow Craig for what that's worth.
All right, Craig with the mic drop. Yeah, it is. It's 6 years. 6 years statute of limitations. So you want to do another one, Mark? You got another question out there that we could hit everybody with?
Sure.
Well, you think about that.
Let's see. Well, let's see who can list 2 or 3 obligations associated, or 2 or 3 duties or obligations of your agency, which might survive closing.
Yeah. Thanks for bringing that up.
Yes.
This is what duties of agency live on. Nice. Yeah. So which one of the fiduciary duties, Cheryl? Remember the old car? There's 6 of them. You know what? I know my agents so well, this loving family of ours, and I'm telling you, there's agents. I know you guys are looking at this list and you're going, oh, confidentiality, that sounds good. I've got the CE thing down, man. All I got to do is watch the chat. Maybe we should come up with a way to, chat us back, Mark, without everyone seeing the answers, But I love you guys. It's all good learning. But you know what? That confidentiality is a big one, isn't it?
confidentiality is a big one, but the way that I think about this is if your buyer and seller obligations and rights live on after closing, which this CE has identified those obligations and rights, then your agency obligations live on as well. So I would argue all of your obligations live on. Confidentiality is the obvious one.
You and I we were kind of debating this. You guys, this is what Mark and I do. Okay, we debate it because
in our free time.
Yeah, we do a lot. We spend a lot of time debating and turning things on its head and everything. But you know, here's where I think the wires get crossed. I'm going to unshare for a second. Okay, put this in your chat. Put this in your chat. What kind of agency do we create when we have a buyer broker agreement or a listing agreement with a client? What kind of agency? What's the category? What do we call it? Let's see who can answer that. It's not implied. It's not expressed, even though it is expressed, but there's a particular type. It's a bilateral agreement. Okay, we're all over the field here, but no bullseye, no target yet. I'll give you a hint. It's not universal agency. Okay, so if it's not universal, what is it? And it's not limited. Limited would have to do with representing 2 or more parties. Okay, I think we got an answer here, Mark, don't we? Shannon, very good. It's specific agency. Okay, it's very specific. And what we remember from real estate school is that when we accomplish the thing we were hired to do, i.e., find the buyer, house, and close, or close the listing for the client, then we've concluded and we no longer represent them in, say, the next transaction or in other things that they do. But this is where the wires get crossed, because living on, the zombies are also in agency. The zombies are in confidentiality. How many times have we said we can't go tell people what our seller sold the property for? They only allowed us to communicate the sold terms to the MLS. They didn't give us permission to share the terms of their agreement with, say, our neighbors, like in a farm letter. Okay? So there's another zombie in agency. And I think that's why we got our wires crossed, because in order to pass the test, Mark, you had to know that specific agency dies. and it's, we all walked away going, look, see, no zombies. But nope, they're zombies. They're zombies agency too. I mean, is there a fiduciary duty that doesn't live on? Maybe that's you've got, obedience, and you've got reasonable care, and you've got confidentiality, and you've got accounting for money. Is there one that they all live on?
Yes.
Yeah. Every duty, fiduciary duty, lives on post closing. So, wow. Right? Wow. Well, one other final thought, Mark, that we got. We're coming up, or just a couple of minutes left. Anything else that we got to get out there?
No, if we can just point to kind of the end of our outline, counseling clients regarding survival. As you study the REPC and revisit this class, if you have questions on how to explain this stuff to your clients, or how to explain survival and what the implications might mean for them, feel free to reach out to your broker, and they'll reach out to me, and we can arrange something to further explain what we've been through today. More than happy to do that.
Sally sent me an email this morning, and I think, Sally, you'd probably had read through some of the handout, and she said, it's beyond me why people would not hire a professional realtor. The more and more you learn about what we do and the scope of what we do and the magnitude of what we do, it screams value. But we've got to do a much better job of slowing down and showing the complexity. When we speed up too fast and we cut corners and we oversimplify, we inadvertently degrade our value. So get down into the details, because frankly, you need to. And this idea that we're done at closing, it's not right. It's not true. It's not real. Okay. Obligations do extend post-closing. We're not just paid to close a deal. We've got to get rid of that poor stigma, and we got to get out there and tackle and alleviate these zombies and cope with these zombies. So, you know, it's a good reason to go get one of those machine guns. You know what a good machine gun is for a zombie? I'm going to show you right now. You ready? I've got one right here on my desk. I've got a really good zombie killer right there. That's a great zombie killer. Know our forms, know our contractual language, use them, show them, illustrate them in presentations, and get down to the details, and you'll take care of those zombies and show your value. All right, so I can't believe we're saying this, but we're going to say, wow, what a great class. We'll put a bow on this. Courtney, Angie, please take one more screenshot. That this is the end of the class, and everybody here, if you want to just type in the thank yous are great. They let me know that you were still there. Go ahead and hit the chat. You guys have a marvelous, wonderful, professional day, and I hope you kill a lot of zombies today and this week. Thank you so much, Mark, and all those who participated. Appreciate you.